KD Mehta versus State of Gujarat on the 1st of September 2000. Welcome to NPA Infracon, YouTube channel, your destination for quality civil engineering education videos. In today's session, we will delve into a detailed case study on KD Mehta versus State of Gujarat on the 1st of September 2000. We will be exploring a series of questions and answers to help you better understand the intricacies of this case. We are excited to present this case study to you, and we hope that it will provide valuable insights into the legal aspects related to motor vehicles and construction equipment. Make sure to subscribe to our channel to stay updated on upcoming videos and educational content. Let's begin our discussion with your host, Rudy. Stay tuned for an engaging and informative session. Question: what is this case? Who have been involved? Judgment: what are the act that has been used? This case involves KD Mehta versus the State of Gujarat, and was decided on the 1st of September 2000 by Justice Mr. Kalla. The case revolved around the classification of various machines and vehicles used for construction projects as either motor vehicles under the Bombay Motor Vehicles Act, 1958, or simply machines or equipments not covered under the Act. The acts referred to in the judgment include the Motor Vehicles Act, 1988, the Central Motor Vehicles Rules, 1989, the Bombay Motor Vehicles Tax Act, 1958, and the Gujarat Motor Vehicles Rules, 1989. The judgment discusses the definitions of motor vehicle and vehicle under the Motor Vehicles Act, 1988, and the exemptions provided under the Bombay Motor Vehicles Tax Act, 1958. It also mentions notifications issued by the Government of Gujarat and the Ministry of Surface Transport of the Government of India in 2000 regarding the classification of construction equipment vehicles as non-transport vehicles. Question: what is matter? Define in detail with respect to Motor Vehicle Act. The matter discussed in the document pertains to a legal case involving the classification of certain vehicles or machines under the Motor Vehicles Act. The petitioner, Larsen & Toubro Limited, a renowned company engaged in construction projects across India, had various types of equipment that were being transported from one construction site to another. The regional transport officer detained these machines at a checkpost, claiming that they were vehicles requiring registration and payment of taxes under the Bombay Motor Vehicles Act, 1958. The central question in the case was whether these machines, such as motor graders, wheel loaders, vibratory rollers, pavers, cranes, and excavator-cum-loaders, should be considered as motor vehicles under the Motor Vehicles Act, 1988, or simply as machines or equipment not covered by the Act. The argument presented was that these machines were special types of equipment adapted for use in construction works at specific sites and were not intended for regular transportation on public roads. The document provides detailed descriptions of each type of machine, their functions, and their use in construction activities like building roads, dams, and bridges. It also references specific sections of the Motor Vehicles Act, the Central Motor Vehicles Rules, and the Gujarat Motor Vehicles Rules to support the arguments presented by both the petitioner and the state authorities. Furthermore, the document highlights the definitions of motor vehicle and vehicle under the Motor Vehicles Act, 1988, and how the classification of these machines aligns with the criteria specified in the Act. It also mentions exemptions provided under the Bombay Motor Vehicles Tax Act, 1958, for certain types of vehicles used in agricultural operations. Ultimately, after considering the arguments presented by both parties, the court ruled that the machines in question, despite being used on public roads for construction purposes, should be classified as non-transport vehicles falling under the definition of construction equipment vehicles machines and are liable to pay taxes. The court laid out specific instructions for the release of detained vehicles and the payment of taxes, while also allowing for refund claims in cases where the vehicles were not intended for road use. Overall, the document provides a detailed legal analysis of the classification of these machines under the relevant laws and regulations, emphasizing the distinction between vehicles used for transportation and those used solely for construction activities. Question: provide detail about the arguments presented by both parties. Petitioner's argument. The petitioner, Larsen & Toubro Limited, argued that the machines' equipments owned by them were not motor vehicles under the Bombay Motor Vehicles Act, 1958. They claimed that these machines were simply machines or equipments used in construction work and were not intended for use on the road. The petitioner emphasized that these machines were transferred from one construction unit to another using trailers or trucks and were detained by the Regional Transport Officer, RTO, at a checkpost in Surat. They contended that these machines should be released as they were not meant for transportation on their own wheels, but for construction purposes only. Respondents' argument: the respondent, represented by the Assistant Government Pleader, AGP, argued that the machines in question, including motor grader, wheel loader, vibratory roller, paver, excavator cum loader, crane, etc., should be considered as motor vehicles. They referred to relevant sections of the Motor Vehicles Act, 1988, and Central Motor Vehicles Rules, 1989, to support their argument. The AGP highlighted that certain notifications and amendments specified these machines as construction equipment vehicles and non-transport vehicles. They stated that even though these machines were used for construction work, they were still liable to pay taxes as they fell under the definition of motor vehicles or vehicles as per the law. In summary, the petitioner argued that the machines were not motor vehicles, but equipment for construction work, while the respondent argued that the machines should be considered motor vehicles and were subject to taxation.